Thank you very much. It's a pleasure to be here today. I haven't spoken at the Samuel Griffith conference for some time. And I thought to myself, seeing this is 9 a.m. on a Saturday morning, you probably don't want a deep and heavy dirge about Section 92 of the Constitution. So I'm going to give you probably what I think at least is a more entertaining romp through Section 92 of the Constitution. We will have brothels, mutiny, snakes, diseased potatoes, a mystery, and Clive Palmer. So that's what I'm promising you for today. I will have to romp through it quite quickly because there's lots to say, so let us get on with it. Now, the late lamented Michael Coper started off his chapter on Section 92 of the Constitution with news of the story about a floating bordello on the Murray River. Now, he thought most Australians would just raise an eyebrow and move on, but, he said, the constitutional lawyer's mind would instantly turn to Section 92 of the Constitution, where it says that intercourse among the states shall be absolutely free. Now, unfortunately, as the constitutional aficionados of this conference would know, that argument doesn't quite stack up because, first of all, the Murray River is actually wholly within New South Wales. We all know the border is the top bank in the Victorian side. And secondly, intercourse has a rather more pedestrian meaning of movement of people, animals and goods across borders. The mystery with Section 92, however, is in its last words, absolutely free. Now, at a first glance, you might think that absolutely free means what it says. That is, that there can be no restrictions at all on border crossing. It was actually described by George Reid in the Constitutional Convention as a little bit of layman's language, none of this finicky lawyerly stuff. But it is clear, both from the text of the Constitution, that absolutely free can't actually mean what you might think it does, and indeed was never intended to mean that. So, let's take Section 112 of the Constitution, for example, not one of the most commonly known provisions. And it says that a state can inspect goods to prevent diseased goods or other dangerous or objectionable goods from passing into the state. It does so by pointing out that the states may levy inspection charges on goods passing into the state. The Commonwealth also has quarantine powers in Section 51(9), which will also prevent diseased goods, animals or people to be restricted in their movements, including movements across state borders. And of course, we've got Section 51(1) of the Constitution, which gives the Commonwealth power to regulate interstate trade and commerce, which is make no sense if absolutely free meant absolutely free of regulation of interstate trade and commerce. So that's the textual background for it. If one, however, is looking at original intent of Section 92 of the Constitution, sorry, pressed the wrong button, the framers of the Constitution, including your inspiration, Samuel Griffith, considered that Section 92 was directed at freedom from taxes, charges and imposts at the state borders. That's basically what it was there for. Now, during the conventions, when John Cockburn and Henry Higgins raised concerns that it might then prevent the states from excluding diseased animals or plants, they were particularly concerned about a disease on grapevines, this concern was rejected by the other framers of the Constitution, and Richard O'Connor observed that the states would retain a right of self-protection so that they could prohibit diseased persons and animals from entering the state without breaching the freedom of trade, commerce and human intercourse. Now, Alfred Deakin, another framer, writing when he was Attorney General in 1902, accepted that interstate freedom of trade is not infringed by a law prohibiting the introduction of diseased animals, and that state legislative powers extend to quarantine and reasonable inspection laws. Paddy Glynn, another framer of the Constitution, later writing as Attorney General in 1909, gave an interesting and slightly more nuanced advice here. He advised that a state inspection law would be unconstitutional if it imposed an unnecessary or unreasonable burden on interstate commerce. He considered that a law that imposed a complete prohibition on certain kinds of plants being brought into a state, healthy and diseased alike, imposes an unnecessary burden on interstate commerce and cannot be justified on the grounds that it's a precautionary measure against the introduction of disease. Note the word precautionary, by the way, that does become relevant when we get to Palmer. If the law were conditional rather than absolute, and the conditions were neither unreasonable nor greater than reasonably necessary to meet the ostensible purpose, then he thought the law would be valid. Now, that's quite interesting because that's an opinion given in 1909, and it's actually very similar in nature to what the High Court said in the Palmer case. Now, the Knox High Court took the same view as Paddy Glynn. So in the case of Ex parte Nelson, Chief Justice Knox, along with Justices Gavin Duffy and Stark, said, "The establishment of freedom of trade between the states is perhaps the most notable achievement of the Constitution, yet it would be a strange result if that achievement had stripped the states of power to protect their citizens against the dangers of infection and contagious diseases, however such dangers may arise." Their Honours concluded that a New South Wales law that prevented diseased cattle from crossing the border into New South Wales, and which required in some cases that the cattle be destroyed if they entered the state, did not breach Section 92 of the Constitution. In contrast, however, we have a case about potatoes. I told you I'd get to the diseased potatoes. So this is a case of Tasmania and Victoria where the High Court struck down the validity of a Victorian law that banned all potatoes from Tasmania entering Victoria because they were likely to introduce a disease into Victoria. This was because the law could have been drafted differently to protect the state against diseased Tasmanian potatoes by providing for inspection of the potatoes as they crossed the border. Again, that becomes relevant when we get to the Palmer case. Okay, so we've dealt with diseased cows and diseased potatoes, but what about diseased human beings? How does it work in relation to them? Well, the first real test of this occurred during the Spanish flu. There were 2 layers of protection for Australia. Australia had pretty good warning that it was coming because it had spread through Europe well before it got to Australia. And the 2 levels of protection were the external border, stopping it coming into Australia, and then the borders between the states. Soldiers returning from war were the most likely people to bring the Spanish flu with them, and so they were quarantined on their ships off the harbour, as you can see there, or at North Head Quarantine Station, which you can also see there. Now, the accommodation at North Head Quarantine Station was quite limited, so when a very large ship of soldiers came, with 900 soldiers on it, they couldn't accommodate them in the buildings, and so they told them to pitch tents in the bush on North Head. Unfortunately, North Head was full of dangerous snakes. This is where the snakes come into the story. And after the soldiers had killed 60 poisonous snakes in their tents overnight, they mutinied. And they did so in a very orderly fashion. This is not them, but it's close to them because they all wore their masks. So they mutinied in their masks and in a very orderly fashion marched out of the camp, daring the guards on the camp to shoot them as they left. Unsurprisingly, the guards on the camp decided that shooting returned soldiers from the war was not a very good idea, and the soldiers ended up marching to the Sydney Cricket Ground where they spent the rest of their quarantine without snakes. Now, once the Spanish flu entered the country, which it eventually did, the next line of protection was state borders. In November 1918, an intergovernmental agreement was reached that if a state identified infection, it would then notify the Commonwealth immediately, and the Commonwealth would then take control over state borders, and it would close those borders to any neighbouring state that didn't have the Spanish flu, and it would only reopen the borders when both states were infected. Now, Victoria as you can see from the cartoon there, did become the first state that was infected with Spanish flu, but it didn't tell, okay? It didn't tell the Commonwealth until a doctor who had a lot of cases finally blabbed to the press. By that time, the Spanish flu had spread into New South Wales. New South Wales immediately alerted on discovering it, and then the following day, Victoria fessed up. New South Wales was furious and said the entire agreement with the Commonwealth was over, slammed shut its border with New South Wales. At that point, every other state thought, right, the deal is gone, every state for themselves. And from that point, states just controlled their own borders. The Commonwealth tried to reassert control, it threatened shipping and all sorts of other things, but the states just ignored the Commonwealth. This might give you a bit of a feeling of déjà vu. So, interestingly, there were issues with Western Australia. Western Australia seized and impounded the transcontinental train as it entered Western Australia and put all the travellers into quarantine. The Commonwealth objected, pointed out this breached the Intergovernmental Agreement of November 1918 and possibly also the Constitution. Western Australia didn't care. There's a lovely article in the Perth News Daily News which said, had we admitted the transcontinental travellers, we might have suffered infection. There was a chance. We preferred to flout authority, break the agreement of November, and even perhaps fracture some constitutional statute rather than court the disaster of the entrance within our borders of the Black Plague. Now, the Premier, Henry Lefroy, found himself stuck in Melbourne, where he'd been attending a Premier's conference when the borders were slammed shut by his acting Premier, Hal Colbach. The actions of the acting Premier, Hal Colbach, were extremely popular in Western Australia. And Mr. Colbach, who not long afterwards became Premier, resisted the pleas of his own Premier and the Prime Minister to reopen the border. The closure of the border was also particularly effective. While Spanish flu did eventually penetrate the state, its delay was significant, and that actually ended up saving many lives. Now, shortly afterwards, Queensland also shut its borders, including to those in border communities, and the Intergovernmental Agreement had tried to protect those and the communities around the borders. That rings a bit of a bell too. Queensland actually charged people a lot of money to enter into quarantine camps. It required them to receive 2 compulsory vaccinations before they could enter the state. There were all too familiar stories of lockdowns, the closure of schools, disagreements about mask wearing, vaccine mandates, and quack cures for the disease. But interestingly, no one sued in the High Court, and the caravan eventually moved on. Okay, so from pandemic, let us move next to the other reason to stop people crossing state borders, and that was war. So the Commonwealth, in World War II, issued a restriction of interstate passenger transport order under the National Security Land Transport Regulations, and it prohibited people from travelling interstate by rail without a permit. Now, according to the official version of events, and we'll get to an unofficial version in a minute, Dulcie Johnson was a young woman. She was engaged to be married. Her fiancé was in the Navy, and he was about to be shipped off to war from his training base in Perth. She might never see him again. She was devastated. So, in October 1944, Dulcie applied for a permit to travel from Sydney to Perth to see her beloved before he left. She was denied the right to a permit, and she went anyway in her last-minute dash to see her man. She managed to buy tickets progressively from different stations to the next, all the way until she got to Port Augusta. And when she got there, she just stayed on the train. Now, she admitted to the conductor when he asked for her ticket that she had no ticket and no permit to cross the border into Western Australia. He said she would have to leave the train at Cook, which was the last stop before the Western Australian border. But when they got to Cook, the station master refused to let her leave the train because he said that the town of Cook was no suitable place for a young lady. Dulcie made it to Perth, where she was duly prosecuted. Her counsel argued that the law breached Section 92 of the Constitution. The magistrate agreed and the charges were dismissed. Now, you might have thought it would have rested there, but the media made a bit of a do about it. It was portrayed as a great love story. Love laughed at rail permits, said one newspaper. But where the newspapers saw this as a story of romance, others saw a conspiracy. And this was because when the Commonwealth appealed the magistrate's decision to the High Court, the young romantic Dulcie was represented by two King's Counsel. The leading King's Counsel in the country, David Morn, whose father-in-law was Edmund Barton, and Garfield Barwick. Now, both of those men were already briefed in Section 92 litigation by the owner of an airline who wanted to challenge the validity of the Chifley government's attempt to nationalise the airline and turn it into a government monopoly. Now, Doc Evatt, who was the Commonwealth Attorney General at the time, thought that Dulcie Johnson was just a pretty stalking horse for the airlines, that the airlines had paid her ticket and used her tale of romance as a more sympathetic way of presenting their Section 92 case on the movement of people across state borders. Barwick, however, claimed that he had in fact spotted an article in the newspaper about Dulcie's case in Western Australia and then rang his instructing solicitor telling him that the Commonwealth would probably appeal and that he should get their client to support Dulcie's case. So yes, counsel for Dulcie were paid by the airlines, but they hadn't actually instigated the case. Now, Dulcie's case did receive quite a lot of press coverage, but interestingly, one of them, as you'll see here, bottom story there, girls had no permits, that's the story about Dulcie's case. And next door to it, the big ad there is an ad for the airlines objecting to nationalisation by the Chifley government. So you can see that the two were issues that were closely connected. Now, here the tale might have ended, except for the researches of one of my students. So a student of mine called Claire Davidson decided to look into the mystery of Dulcie, try and find out whether she ever married her beloved. Now, Claire's investigations revealed another beautiful blonde woman who used the alias of Dulcie Johnson, amongst many others. She was also known by the press as the Angel of Death and the Black Widow. This Dulcie Johnson was a notorious Sydney underworld figure. According to the press, at least 8 of her husbands or lovers had been gunned down or stabbed to death, and she had more than 100 convictions for various things, including running brothels. See, I told you we'd get back to that. Okay, now we do know that Dulcie did travel to Perth from her East Coast dens of crime because she was actually convicted of running a brothel in Perth in 1946. So, was she the same Dulcie Johnson who had no permit to travel to Perth in October 1944? So, being a good researcher, I thought, well, time to go to the archives and go through the file on Gratwick and Johnson. Interestingly, in the file, there are 2 red flags. The first is that the records state that proof of Dulcie's identity was waived. So no one actually checked who she was. And this is actually specified in a number of points on the records. They just took her word for it in terms of what her name was. The other flag is that in the record of interview, Dulcie actually named who her fiancé was in the Navy. And if you now look at the war records, no such person existed. So we're pretty confident that Dulcie's story of love and romance was definitely a ruse, but whether or not it was the case that she ended up being this particular gangland figure, we're not absolutely sure. It may have been the case that Dulcie, fleeing her crimes in Sydney to run a brothel in Perth, decided to get on the train and then come up with a great story of romance. But did she end up getting the most eminent King's Counsel in the land to represent her for free in the High Court? Perhaps. Unfortunately, we don't know. What of the law, you may ask, after this rather entertaining story? Well, the High Court accepted that transport is intimately connected with defence, and that defence power could have been used to support a law that restricted transport. But it was still subject to Section 92. If the law had been one that regulated train travel for defence purposes, including both intrastate and interstate train travel, it could have been valid. But here, there was no defence justification given for restricting the interstate train travel, and indeed, there had been no restrictions placed on intrastate train travel. So as they couldn't justify the order was held invalid. Now, from the beautiful Dulcie, we move to Clive. Now, Clive Palmer challenged the validity of the closure of the Western Australian border during the pandemic. And as you know, his challenge failed. Now, because I've decided not to completely traumatise you with that photo for too long, let's just go to a more innocuous one of the High Court. So, the High Court comprised of 5 judges, because Justices Bell and Nettle there were about to retire, could have dealt with his case in the same way as diseased potatoes. The court had previously concluded that you can't exclude all potatoes if there's a way of inspecting them so as to exclude the diseased ones. But here, on the basis of Justice Rangier's findings of fact in the federal court, there was not an accurate way of identifying whether a person might be infected with COVID-19, and the risk of the disease entering and spreading through the state was high, with potentially catastrophic results. A precautionary principle, as mentioned much earlier by Paddy Glynn, was applied. It could therefore be concluded that the border closure was reasonably necessary and proportionate to achieve the legitimate end of protecting public health. The main difficulty with this argument, however, is a timing one. Throughout the period from the commencement of the challenge to its determination, the degree of risk of the spread of COVID during the pandemic did vacillate wildly, leading to the odd prospect that the border closure might be a proportionate response at one point and not a month later, but then might be valid again 2 months after that. Now, this raises all sorts of interesting issues about whether a law can lose and regain its validity due to changing factual circumstances as a consequence of a proportionality test being necessary conditioned for its validity. That's an entirely different conference paper, which I'm doing for something later in the year. But what's interesting here is that the High Court just ducked these issues. In fact, it didn't address at all the validity of the order that closed the border, let alone the validity of it at different times. Instead, it did 2 rather odd things. First, it mucked around with the test for Section 92, trying to create what it calls coherence by providing a single test for both the trade and commerce limb and the intercourse limb of Section 92. That test is focused on discrimination, fine, but it left unclear whether protectionism is actually still needed to trigger the application of the trade and commerce limb. 2 judges said yes it is, 1 said no it's not, and the other 2 didn't say. Okay, so complete fiasco there. The ramifications of dropping protectionism are actually potentially enormous, don't have time to go into that, but were obviously not argued in the case because the case concerned the intercourse limb. And it's a good example of why courts should not go beyond the scope of the case before them in changing constitutional tests, and if they do change them, should be absolutely clear about what the new test is and how it applies. Too often, the High Court meddles to create a single coherent test when all they do is achieve conceptual uncertainty. The second odd thing the court did was refuse to decide the constitutional validity of the order and instead only address the constitutional validity of the legislation that authorised the making of the order. Now, the theory here was that if the legislation is constitutionally valid, then any order that falls within the scope of the authorising legislation will also be valid. But this becomes problematic if you're having to apply a proportionality test, as the court says you must. So the provisions of the Emergency Management Act were drafted broadly to deal with any possible emergency, not just a pandemic. So how do you then assess whether they are suitable, reasonably necessary and adequate in their balance in giving effect to a legitimate purpose if you are unable to look at the actual nature of the order made under the Act, such as a border closure, and its effects on the actual circumstances, the circumstances of the COVID pandemic? And this shows why the court's new rule doesn't actually work. And you can see that illustrated in the judgment of Chief Justice Kiefel and Justice Keane, where they did end up assessing reasonable necessity of the law against alternatives to closing the border and the level of risk imposed by COVID. In effect, they were assessing the order rather than the authorising statutory provisions, despite just telling us that we weren't allowed to do that. Now, the other judges did try harder to stick to assessing the sections in their generality, but this leads to the other problem that now these provisions of the Emergency Management Act have been held to be constitutionally valid, so that any future border closure must now be assessed as an administrative law challenge confined to whether it falls within the scope of those sections. Well, what if a border closure in the future is not reasonably necessary? Unless you can actually then force that into a ground for administrative law review, such as it was made for an improper purpose or based on an irrelevant consideration, then the lack of proportionality of the border closure is now irrelevant. The High Court simply won't assess its constitutional validity, and that seems to me to be a very perverse outcome. Overall, the Palmer judgment is far from satisfactory. It might have been a convenient way of ducking the difficult issues and shoving them off to an administrative law challenge in the future, but the long-term consequences may prove problematic for decades to come. As for Clive, well, he had to pay for his lawyers and the costs of defeat, and he still couldn't get into Western Australia. Dulcie, however, did much better. She was not just a pretty face. Thank you.